Welcome to the BreakPoint Podcast. Another week of Supreme Court decisions, starting on Monday with a very important decision in our view. We had a BreakPoint on it that came out on Tuesday. We'll link to it if you come to breakpoint.org. A decision in a case in Louisiana called June Medical Services versus Russo. It had to do with whether the Supreme Court would allow any sort of restrictions there in Louisiana. And the decision came back surprisingly 5-4, with the Chief Justice siding with the liberal side of the court, shall we say, again, as he's been apt to do. And I wanted to talk about this decision and how significant it is. In our view, it's quite significant. Not everyone shares that view, but I think it is. And so I'm just really pleased to have Dr. Charmaine Yoest, who's the Vice President of the Heritage Foundation. She leads the Institute for Family, Community, and Opportunity. There includes work on domestic policy issues, healthcare, welfare reform, education policy, family formation, women's issues, and religious liberty. So she is exactly the right person to talk to about this case. And Charmaine, it's great to have you on the program. You've been a longtime friend of the Colson Centers and really appreciate your work. So some people are looking at this decision saying it's not that big a deal. The Texas law, upon which the Louisiana law was very similar, was already struck down. It was, no surprise here. I think it's a big deal. So what say you? No pressure. What say you?
No pressure. Hey, John, it is really good to be with you. Although we needed to come up with a better reason to get together.
Exactly. It's like we all of us get together when something bad happens, and the Supreme Court's been a doozy already this term.
Well, it really has been. And, there's no sugarcoating the fact that we're really, really disappointed in how the Chief Justice ruled in this case. And it's not just, there's times when we expect judges, particularly Supreme Court justices, to come to the court without a pre-existing agenda and to rule according to their best intellectual judgment. And I think what's particularly frustrating to everybody is that this one is a real head scratcher. You're seeing all of the great legal theorists just saying this makes absolutely no sense whatsoever. And the background is that 4 years ago, Justice Roberts, in the Hellerstedt decision, which was the previous decision that you mentioned, he dissented from the court's decision, saying that he thought that that there was a reason to be able to regulate abortion clinics. So at the time, he said that the case 4 years ago was wrongly decided. And now, just a few short years later, when he had an opportunity to join a majority, to form a majority, to overturn that decision, he decided to cite precedent as being the reason that he wasn't going to do that. So it is, even as you and I talk about trying to make it sound like it makes sense, is really difficult.
Well, it is. And let's just review. The Hellerstedt decision in Texas had to do with the state of Texas putting regulations on abortion clinics, saying that abortionists needed to have admitting privileges to nearby hospitals. And as you said, the majority said that was unconstitutional. It was an undue burden. Which is, of course, a category that was invented out of a case called Planned Parenthood versus Casey. And again, Justice Roberts at the time said Texas is completely justified in having that sort of regulation over the abortion industry.
Right.
And in Louisiana, which was a very similar law, and I want to talk about how similar it was, but Louisiana and Texas aren't the same state, and the situations on the ground were pretty different. And so in Louisiana, strangely, he sides with the court precedent as opposed to the decision. Were there significant differences between the Louisiana law and the Texas law?
Well, it's just the fact that you have to ask, if they weren't different, why was the court willing to consider it? That in and of itself should tell you that there was a significant enough difference. Mm-hmm. The court doesn't waste their time. People work pretty hard to get the Supreme Court to consider something. So there were definitely different issues on the table. And certainly the Louisiana legislature had put together a really, really significant and serious dossier against the abortion clinics and against the abortion doctors in the state that justified requiring them to have the admitting privileges. I mean, they had an example of an abortion clinic that had used an ophthalmologist as an abortion doctor. I mean, people need to understand what we mean by admitting privileges. Basically, all it is having an abortion doctor within 30 miles have to have the ability, if something goes wrong in an invasive surgical procedure, to be able to accompany his patient to a local emergency room and be able to give them service there. That's all. That is all that we're talking about. It's just really kind of common sense stuff. And frankly, I'll have to say, because you know me, I've been a longtime advocate for looking at abortion in the context of how it harms women, and a longtime advocate of these kinds of regulations, because I believe at a bare minimum, we should be talking about the fact that women deserve to be protected in a situation that they expect to be a healthcare setting. And yet, the conservative justices who dissented from the liberal majority made the case that there is a horrific conflict of interest here in having these abortion doctors come forward and say that this is an undue burden for women, that the doctors are being required to meet a professional standard. So who's protecting who here? And I think if you clear everything else away, this is kind of a smaller, more esoteric point off to the side, but I'm glad to have a context like this where we're having a longer conversation where we can talk about that kind of conflict of interest, and that it's kind of just a throwaway comment in the dissent.
That just kind of underscores there's just ways that Planned Parenthood has gotten away with things. I know your expertise is in the legal side and the policy side. As a person of faith, I just struggle to see how could Planned Parenthood dodge so many bullets, so to speak. I mean, you go back to Gosnell. One situation like that in the pregnancy care center world would have shut down the whole thing. Not to mention unregulated, lack of regulation and conflicts of interest and federal funding and what Lila Rose has revealed in terms of their willingness to break the law,
Right.
the lucrative money that they get. It's just stunning. It's almost like there's a demonic power here that's just holding this together. There's just no other explanation, especially in our woke society, how, they wouldn't have been canceled with all of these foibles, but they haven't.
Well, and that's what's really troubling. There's that long-term joke about conservatives coming to Washington, D.C. and growing in office. And, there's no denying that there's this temptation that people have to come to Washington to get appointed to places like the Supreme Court and suddenly want to be seen as, kind of a little bit cooler than they were before. And, that's a real problem in this context where it's kind of fascinating, talking about the fact that this decision by Judge Roberts is absolutely inexplicable. In the last several years, there's been 2 cases that he's ruled on where he's been willing to overturn precedent that is much longer and more established. And in fact, in one of those cases, he actually authored the opinion. He actually authored the opinion overturning a precedent. So even people who are much further to the left than you and I are kind of scratching their heads and saying, wow, this was quite a win. This was quite a win for the abortion lobby to have the Chief Justice kind of making this up as he goes along.
So you may not want to comment on this, and if you don't, I understand. I mean, the issue here has to do with a setback for the pro-life movement. I think a serious one. But you look at Justice Kennedy, for example, and it would seem like Justice Kennedy's ultimate agenda was, I call it non-animus. Like he always wrote, he doesn't want anyone to have animus against anyone else. And he would do these, flat out inventions out of midair in order to get there and advance, minority rights, and certainly with Obergefell and others. Roberts seems as his priority of being a Chief Justice is the integrity of the court. It's like he's very worried that the court will lose credibility at any level. Are we seeing that across the board? I mean, that he's kind of, again, I mean, his absolute hesitancy, in his opinion to say, we've just got to go with precedent. I mean, it just doesn't make sense from his history. It doesn't make sense from the court. The court's overturned, as I understand it, precedent about 300 times in its history. The court will do that. Is there an agenda here for Chief Justice Roberts?
Well, listen, and we can't underscore enough the spectacle of him having said just 4 years ago that the court had decided wrongly. So it's like, in terms of your sacred duty as a justice to put the Constitution over precedent, just from the get-go, he's violating that. But the fascinating thing to me, listening to you talk about his motivations and being concerned about stability of the court and those kinds of things. Even the head of NARAL, who's I consider her a friend. We've debated vehemently over the years. So yesterday she tweeted out exactly the same thing that you're saying. Just that, hey, this is a fantastic win for us on the abortion side. And, this is a good example of how bringing pressure to bear underscores for the justices that the court has to follow precedent and remain stable. And that kind of thing is like, for them to be taking a victory lap over something like that is really, really troubling, because the justices are put on the court to uphold the Constitution, not to blindly say, I think the precedent is wrong, but I'm going to uphold it anyway. That's not at all what stare decisis is supposed to be about.
So let's dig into a little bit of what Justice Breyer wrote in his majority opinion, and then what Justice Roberts wrote. The thing that this decision seemed to elevate at a very disturbing level was this kind of undue obstacle or significant obstacle to a woman's access to abortion. That is a Mack truck sized caveat that you can drive almost anything through, right? And it goes back to Planned Parenthood versus Casey, but to see that escalated, it was almost like, well, from here on out, any case having to do with abortion is going to be judged fundamentally on that. And of course, that's been a central issue that the court has tried to look at. But it just seemed to be an elevation of that principle, and
Right.
almost to mean any inconvenience whatsoever to a woman at any level to make a decision about abortion then is unconstitutional on its face. Is that an overstatement to the sort of language that we saw in the opinion yesterday?
I don't think so. I think that's important for you to kind of hone in on that. And I think what I would emphasize is that sometimes you can kind of get the impression that these cases meander along and then, they end up at the Supreme Court. I think it's important to kind of go back and look at the track record of how things get to the Supreme Court. And the fact that the district court overturned the Louisiana law and said that it was an undue burden.
Mm-hmm.
And then the Fifth Circuit came back and said that it was clearly erroneous to call these regulations an undue burden. So it's not just us in the pro-life movement saying this. There was another court that looked at it and said clearly erroneous. So your point about Kermit Gosnell and the fact that there are trends that happen and events that affect how the court looks at things. Louisiana was responding to the fact that the Kermit Gosnell case was such a tragedy. The fact that someone died in his clinic. Her name was Karnamaya Mongar. And when they got inside his clinic, they were all horrified to discover that the conditions were so appalling, and that the health inspectors had not been in there for a considerable amount of time. And so Louisiana was reacting to that and looking at their own track record in Louisiana and seeing clinics who were having ophthalmologists perform abortions and other really egregious violations of health kinds of requirements. And so, the Fifth Circuit looked at that track record and looked at that accumulation of evidence in the court record and said, there's the legislature was in their right to make this decision. And let's also drive home the point that this was not a Republican-led effort down in Louisiana either. It was a Democratic representative who was driving the legislation and sponsoring it, and a Democratic governor who signed it. So, these are all relevant factors in terms of looking at how politicized the right to abortion has become, and now that politicization has reached the highest court, and that should be troubling to everyone.
Yeah. What are the other cases that are out there right now, or the other state level legislative initiatives that are in danger because of this decision?
Well, one that's really near and dear to my heart is a case that makes it illegal to abort a baby because of Down syndrome.
Mm.
That's going to be interesting to see what happens with that as it makes its way through the courts. To me, the reason I say it's near to my heart is I just can't imagine in America that is not something that we could all come together on. We have Down syndrome kids who are performing as models now in major ad campaigns nationwide. I would highly recommend to everyone the movie The Peanut Butter Falcon that my family and I just watched last weekend, that has as the
I did a commentary on that, Charmaine. It's a remarkable film. I mean, there's language. It's salty language. Let's I want to give that prerequisite, but it's a remarkable movie and just a beautiful story.
Yeah, so it's amazing that you could have a main character who is a young Down syndrome man, and yet still in this country we would have any debate whatsoever about whether that's a legitimate reason to abort a baby.
Yeah, I mean, one of the most remarkable things about that story is the impact that lead character, a young man with Down syndrome, had on, I forget how you say his name, Shia LaBeouf, is that how you say his name?
Exactly.
Who's really just had a rough couple of years and really credits him in many ways. And it's a remarkable story of how the film was even made at the beginning. We'll link to that BreakPoint commentary at breakpoint.org. So can we back up and maybe include the decision last week that we received as far as the Harris Funeral Home case and the Bostock decision?
Right.
Which we talked last week on the podcast with John Birch, who was the ADF attorney that argued that case on behalf of the Harris Funeral Home clients. But that was also Justice Gorsuch, a Republican appointee. We've got John Roberts, a Republican appointee. We've got a conservative majority to the extent that, I mean, there was some hysterics from the left that this is going to overturn Roe v. Wade, that this is going to set back, LGBT rights, that this is going to be a court that, essentially ruins, the future of liberal America. And it's actually turned out, at least for this term, to be the exact opposite. Should conservatives and Christians be worried about this court?
Well, let me respond to that in two ways, because I'm concerned that there will be a takeaway message among some people that it's hopeless and they're just going to kind of wash their hands of being concerned about the Supreme Court. But something that a mentor of mine told me many years ago that I always stuck in the back of my mind was that, we have an idealistic notion sometimes of the Supreme Court as being, this, ivory tower situation, and they're, these intellects considering a case. Well, the truth of the matter is they are human beings. They do live in a political world. They do respond to political pressure, and they do have this sense of deciding cases in the context of where the culture is. And so we have to be realistic about the fact that major decisions that are going to change the real fabric of our country, like our ultimate hope of making a difference in the jurisprudence related to Roe v. Wade, you need a larger majority. That 5-4 that we continue to live with is really, really tenuous. And I think to kind of add on to that, my second point is that I think the left is more in tune than we are with the reality of the debate that goes on at the Supreme Court, and how important it is to have people on the court who are willing to have those debates and to work to persuade their colleagues. That's just really, Justice Scalia was known for doing that kind of thing, of working to be persuasive even before the cases were written, and so, or the arguments and the opinions. So I think that rather than be discouraged, we have to just kind of tighten up our belts and say, this is a tough business, and you have to be in it for the long haul, and we just have to keep persisting and moving forward, and frankly have to understand that this is the future of the courts really, really is on the line in this presidential election in 2020. The Heritage Foundation is a 501c3, so I'm not going to be overly political about this, but I will just underscore that people need to be paying attention to this issue as we get into debates. We need to hear from both candidates as to what they're thinking about their appointments, and really, really keep a focus on the future of the Supreme Court as a central issue.
Yeah, it is a central issue, and it's hard right now because I think some people are arguing this proves that it's not a central issue, right? I mean, you put your hope, at what is it? So many of the last 18 or so Supreme Court justices, is it 14 or 18 or something, that were nominated by conservatives, many that evangelicals or people of faith voted for. And it's, how many times do we hear the analogy of Lucy with the football, right? You're like, here's the Supreme Court, and then she moves it at the last minute. And I feel that. I feel that at times, like, good heavens, like, we were told this was the court. I was an advocate, for example, for Justice Gorsuch, and just stunned, not only by the decision, but by the opinion. How he got to that decision was just so troubling last week. And yet I can also look at it and go, the two Supreme Court justices in this first term of President Trump, and what would it have been had it been a President Clinton? We know what, how different it could have been. How do you balance that discouragement with the realism?
Well, you and I have been doing this for many, many years, and so this is not the first discouragement that we've had, and so it's part of it, and you just have to, you have to be in it for the long haul, and have to realize that the courts and the culture are not separate, and we have to continue focusing on making the arguments in the culture and moving the culture. And I think that there's the pro-life movement has been doing a lot on that front, and but at the same time, having the two elements move forward together. I'm a big believer in knitting those two pieces together, and so we have to redouble our efforts and be sure that we're making the case. And frankly, I think that if anything, if there is a silver lining, this gives us an opportunity to talk about the health risks for women in, why did we care about this case? The left likes to caricature us as being only about overturning Roe v. Wade. Well, come on, there were some real reasons. There was a real case record as to why the Louisiana legislature felt like they needed to move and to protect women within their abortion clinics. So I would encourage people to look at the decision, look at the arguments, and then focus on how we continue to refine the arguments that we're making, frankly, to women themselves about this decision that so many people are confronted with, and why we have the beliefs that we do.
That's such an important point. I mean, because the talking point on the left and in left-leaning media has just been quickly, well, this was a ploy to tackle Roe v. Wade in Louisiana. It had already been struck down, and abortion is a safe procedure. It's as safe as, what have we heard? It's as safe as almost anything. Well, of course, it's as safe as that if you don't think that a life is being taken, if you take that out of the equation up front. But also the health risks for women are just dramatically understated, especially when we look at long term. The other thing about this decision, Charmaine, that really troubles me is it's been some of the great strides of the pro-life movement have been that have made such a difference have been the local ones, the state level ones, the community level ones. And here you had a state basically with different situations on the ground. We talked about this in a BreakPoint in terms of the number of abortion clinics that would be closed, how far women would have to travel. It was a very different situation than Texas. And yet it was kind of a one size fits all from Justice Roberts, which is, if it was, unconstitutional in Texas, it's unconstitutional in Louisiana. as if we were talking about the same state, the same situation on the ground. Is this doing damage, and will this do damage in the short term or the long term for state level, actions, regulations on the abortion industry that are really dependent on factors on the ground?
Well, I think that's why it's important for you and I to give out a message of encouragement and support to people who have been working very hard at the grassroots level to advance pro-life legislation. My experience though of these people is they're pretty hardy and they're pretty tough.
They are, aren't they? They're just amazing folks.
They're really committed to the cause. And, one thing I would emphasize is, look, this is a really bad look for the abortion lobby. If I were them, frankly, I wouldn't, I'm not in the business of giving them advice, but to me, I've always thought that it was a really bad look to be saying, hey, listen, our doctors are so cut rate that that we think it's really too much to ask for them to have admitting privileges at the local hospital. Like, what kind of shyster are you putting off on women? So I would underscore, what is the actual argument that our opponents are making in this context, that they don't have to meet the same regulations that other healthcare providers do. I think we need to keep hammering that point home, so that over time we do make progress in the cultural setting, and I think frankly it'll come back around in the law as well.
Well, my guest today on the BreakPoint Podcast has been Dr. Charmaine Yoest, Vice President at the Heritage Foundation, where she leads the Institute for Family, Community, and Opportunity. Also, check out her book, Mother in the Middle, which was published by HarperCollins. Has talked a lot about the centrality of family to civil society. And also, we should mention, just has finished a stint in the Trump administration at Health and Human Services. And you just in the spirit of elections have consequences,
Right.
HHS is the clearest example in my mind of the difference between the last administration and this administration. It's really a stunning difference. And with Roger Severino and with you over there for a while, just a remarkable difference. And it just reminds you that it's not just one candidate versus another candidate. It's about 3,000 people that are involved on either side of the coin. And the progress at HHS has been remarkable. So congrats on that as part of your tenure and as well. But thanks for giving us a little clarity on this. Really appreciate that.
Well, it's great to be with you, John. I so appreciate the work that you guys do as well.
Thanks so much.
Take care.